Greetings, everyone. Thank you so much for coming tonight. I am Jeffrey Rosen, the president of the National Constitution Center, which is the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. And today, all of us at the National Constitution Center are mourning the loss of Justice Antonin Scalia. He was a towering figure of 20th century jurisprudence who transformed the debate about the Constitution. Our panelist will have some words in his memory, and we will have a podcast on Thursday with his former clerks discussing his legacy, but I'd like to invite all of you to take a moment of silence in Justice Scalia's memory. Thank you so much. I think that I'll avoid plugging the future town halls right now and introduce although they're excellent, and we're going to be having a series of discussions of the presidency and the Constitution, voting rights, a new program on policing and technology, but if you check out the website, and please come often during this winter season. Let me now introduce our panelists. These are the most distinguished scholars in America on one of the most urgent questions before the Supreme Court today, and that is the constitutionality of President Obama's executive actions about immigration. I'm going to introduce them very briefly, and then we will begin our discussion. Josh Blackman is Associate Professor of Law at South Texas College of Law and author of Unprecedented, The Constitutional Challenge to Obamacare. Adam Cox is Robert A. Kindler Professor of Law at NYU. Cristina Rodriguez is Leighton Homer Surbeck Professor of Law at Yale Law School. And Nicholas Quinn Rosenkranz is Professor of Law at Georgetown, Fellow at the Cato Institute, and a great partner of the National Constitution Center for our wonderful debates with Intelligence Squared. Please join me in welcoming our distinguished panelists. Thank you all so much for being here. I think it is appropriate to just ask each of you to offer a few words on Justice Scalia's life and legacy. I'll just begin by saying that he must be counted as among the most influential justices of the 20th century, ranking with William Brennan and Louis Brandeis, because he changed the terms of constitutional debate. Justice Elena Kagan, when she was dean of Harvard Law School, said more than any other justice on the court, Justice Scalia has changed the terms of debate, compelling liberals as well as conservatives to make arguments about constitutional text and history and addressing him in his own terms, which was a very notable tribute. Adam, let me ask for your thoughts on Justice Scalia's legacy. How will he be remembered? How influential will he be in the coming years?
I mean, I think you're right that he was a tremendously influential figure, maybe the most influential judge of the last generation. I never had the opportunity to meet him, but I think like many great judges and justices, the extent of his legacy, I think, is seen maybe most clearly in the clerks he produced. And I've met a lot of those clerks, and whether they were conservative or liberal, in whatever profession they pursued, they are an incredibly impressive group of lawyers. And that itself, I think, is a testament to his legacy.
That's a wonderful observation. And he was famous for choosing at least one liberal clerk, because he loved to be challenged. On our podcast, we're going to have Larry Lessig, who is now a very distinguished cyberspace scholar who believes Citizens United should be overturned, but he was a Scalia clerk, and Scalia loved sparring with him. Nick.
So I'm actually really still grieving about this. He was a hero and mentor for me. I'll offer a quick recollection. I clerked for Justice Kennedy, and the tradition is that each justice's clerks invite each other justice out to lunch. And so we invited Justice Scalia out to lunch at AV Ristorante, his favorite restaurant, his favorite pizza place. And we went out with him, but we were all sort of in awe of him. And so it started out a bit awkwardly. We were each, kind of not sure what to say and how to, and the whole thing was, a tiny bit awkward for the first couple of minutes. And then I described to him the article that I was working on, that I was writing at the time, which was Federal Rules of Statutory Interpretation, my first article. I said, do you think Congress could actually tell courts how to read statutes? And he hadn't thought of that before. And it was like, first of all, it was amazing to watch his mind at work, to latch on to this idea and find its difficult fault lines and find the tricky hypotheticals immediately. So brilliant, of course, but what I remember most was he was like a child with a new toy, given a new idea to play with. He lit up at legal reasoning and intellectual kind of sparring. Giving him a new idea to kick around was the best thing you could give him. So.
It's a wonderful example. Several commentators have attested to that. He made constitutional law exciting because of his zest for ideas. I had the honor of one dinner with him as well, and just went right to the question that had always bugged me. How do you justify Brown versus Board of Education with your originalist theory, given the fact that the framers of the 14th Amendment clearly did not intend to forbid segregated schools? And he first had a huge belly laugh, and he went back and forth a little bit, and basically at the end he said, well, no theory is perfect. So, so he was willing to concede, and it was just a delight. Cristina.
So I think as a professor of constitutional law, it's hard to imagine a world without Justice Scalia, and I think his legacy will live on in the fact that he is an essential teaching tool. His opinions, I find, even though I disagree with many of them, are the most useful teaching tools. Not because of the language that he uses, which has gotten a lot of coverage and definitely gets a lot of laughs and admiration, but because he takes positions very clearly, and they're supported by theories. And that might not be the right way, the best way to be a justice, but in doing that, he forces conversations and he brings the Constitution alive to students in the classroom. And so I think we'll be grappling with him for many years.
It's a fascinating point. It's obviously great for us law professors to have justices with a theory by which they can be measured. Do you think it's important to have a theory to have influence on the court?
I think to have lasting influence, I think it is important to have a theory and to change the way the lower courts decide cases and to change the way scholars think. I'm not sure it's the route to influencing decisions or the best route to influencing decisions on the court itself, and that more pragmatic justices might actually influence outcomes more, but I think that sort of influence based on theory transcends the outcomes of individual cases in a term.
And Justice Scalia himself acknowledged this. He said he believed his greatest influence would be not on his colleagues, but on generations of law students and thinkers.
I think that's right.
He also introduced this distinction that I'm always urging on you whenever you come here, which is that don't assume it's all politics and try to draw a distinction between your policy views and your constitutional views. And that distinction is the core of our intelligence squared debates. You can criticize Justice Scalia for saying that in some cases he wasn't always true to that principle, but in others he certainly was. And the fact that he insisted on that distinction is one that we try to teach students, and I'm eager for you to grapple with as well. Josh.
So Justice Scalia told us what his legacy is. He wrote an article in 2009, and he wrote, "What endures is what happens in the classroom." Far before he was Justice Scalia, he was Professor Scalia, and he was giving a lecture to law professors on what matters the most, and he said, that's where your legacy will be in the classroom, and passing on your spirit of the law to others who will pass it on once again. And that's what we're here tonight to do, to pass on the spirit of the law and to inspire a spark in the Constitution. And I'm very grateful to Jeff for welcoming us to this wonderful center, which is a huge public service.
Thank you. That is beautiful, and we will try to honor Justice Scalia's memory by having the kind of vigorous and engaged constitutional conversation that he had so much zest for. So Josh, our question today is, did the president violate his authority to take care that the laws are faithfully executed when he used his executive authority to defer the deportation of millions of immigrants living in the US illegally? And Justice Scalia gave us a sense of what he thought about this question. He commented on it very explicitly in a case from 2012. Tell us what he said and how that sets up our debate.
So it is with great sadness that we will never see what Justice Scalia has to say in the case of United States versus Texas. But he gave us a hint, speaking from the great beyond in 2012, when he commented on President Obama's first action immigration called DACA, Deferred Action for Childhood Arrivals. And this deferred the deportation of roughly 1.5 million dreamers, people who came here illegally as children, stuck around, graduated from school, became good people. And Justice Scalia said, a husbanding of scarce resource enforcements can hardly be the justification for this, since those resources will be eaten up by the considerable cost of conducting the program. The president has said the new program is, quote, the right thing to do in light of Congress's failure to pass the administration's proposed revision of the immigration laws. Perhaps it is so, though Arizona and Justice Scalia may not think so. So what Scalia was basically saying was, even though the president justified this policy by saying it was the right thing, Scalia did not believe it was a faithful execution of the Constitution. Now, that issue is in no way implicated by the 2012 case, but is squarely teed up by the Supreme Court for resolution this summer. Hopefully we'll get a decision on the merits. We don't quite know, but I hope you'll enjoy this discussion where we debate whether the president has complied with his duty to take care that the laws are faithfully executed.
Great, thank you for reading that. Cristina, was it, what do you think of the fact that Justice Scalia reached out to comment on this question that wasn't before the court, and then give us a bit more context about how his observations relate to this question of whether the Constitution was violated?
I think it was unusual that he addressed a program that wasn't before the court and possibly undisciplined, but it also speaks to what he often did in his opinions, which was to highlight controversial, salient issues. And it wasn't unrelated to the issue in that case, which was about the scope of the executive branch's discretion to make enforcement judgments. I think that he clearly would have been against the government in the current case. But what really matters is that two of the justices in the majority of that case, Justices Kennedy and Chief Justice Roberts, may actually conceivably side with the government. In that case, Justice Kennedy articulates a theory of executive discretion that says the president has to make choices about who to deport. And it's not a rote decision. It's a decision that requires taking into account humanitarian factors, foreign policy, trade policy, a whole host of different matters. Now, the extent to which he believes that, I think, is at issue in this coming case, or the extent to which he would take that theory. It doesn't mean that he needs to decide with the government here. Maybe the discretion was used, in his view, in an overly broad way. But he has given us a view that the executive branch has a great deal of discretion in deciding whom to deport and how to structure those decisions.
Very interesting. After we've talked some more, I'll ask each of you to kind of imagine how the justices might vote. But Nick, you testified before Congress on this very question. And why don't you tell us first what the Take Care Clause says, why you believe that the program at issue here, which is the Deferred Action for Parents of Americans and Lawfully Permanent Residents, or DAPA, violates the Take Care Clause, and why the court even decided to raise this constitutional question, which the lower courts hadn't considered.
Yeah, I wonder if we should maybe take a minute and just tee up how this,
describe the case.
What is at stake here. So Congress has the power to make laws and has made the immigration laws. And the president is obliged by Article 2 to take care that the laws be faithfully executed. Now, the president announced that as to a category of folks, which numbers, several million people, he's going to not enforce the immigration laws as to those folks. He described the categories, that as to those several million people, he's not going to enforce the immigration laws. The question is whether that declaration is consistent with his obligation to take care that the laws be faithfully executed. So how do we think about that? At a first crack, we look at the constitutional text and try to see what we can glean from it. First thing to notice is it is a duty. It is an obligation of the president. He shall take care, it says. Second thing to notice is that it's a personal obligation. It's an obligation of the president. It's not an obligation of the executive branch quite. It's a personal obligation of the president. Now notice, that's not to say he's going to execute the laws himself personally. That would be impossible. But he's the one who's going to take care. He's the one that's going to make sure that they are faithfully executed. And then finally, notice this word faithfully. So it doesn't say that he will take care that the laws be completely executed entirely, and it doesn't say that because that would be impossible. He doesn't have infinite resources, and so that means he's going to have to make some discretionary choices about how to enforce. Traditionally, we think of those choices as case-by-case choices. So the president says, look, I see that you've committed this crime, but it's a little crime, and I have a lot of other things to do, and it's simply just not worth the resources vis-a-vis you. I'm going to let you go with a warning or whatever, and move on to the more important case. That's how we usually think about that choice. This looks different. This is announcing preemptively as to millions of people, I'm not going to enforce the law as to you. And the question is whether that's different. Can he really actually do that? The scale seems different, and it has a bit of a legislative character to it. Describing these class of people, it sort of sounds like what you'd expect Congress to do. And indeed, Congress considered doing this exact thing and decided not to. So this looks a little legislative. It doesn't look quite like we usually think of prosecutorial discretion. That, I think, is why the court has reached out to consider this question.
Great, thanks for that great summary. Adam, as I listened to Nick, it sounds like he's saying that Congress considered passing a version of this law and decided not to, and the fact that the president is deciding to do it in the face of congressional silence means that there's a constitutional violation. Have I got that right? And what do you think of that argument? What's the response?
So I do think that one of the arguments that was raised early on was an argument that Congress had communicated through its inaction that the president was constrained against taking discretionary actions to decide which folks from among the very large pool of people who are currently deportable in this country would be removed from the nation. That's actually not a position that's been pursued by the plaintiffs in the case, interestingly. And instead, early on, their principal challenges were, as Nick also suggested, that maybe just the scope of the program is too big. Whatever Congress may or may not have said, they couldn't have intended for the president to be able to protect this number of people from deportation. That may be one core problem with the program. And the second problem is the kind of categorical nature. They couldn't have intended for the president to be able to make his choices in this fashion, announcing publicly the clear criteria that would lead to the protection of millions of people. Now, I think interestingly, as the litigation has proceeded through the courts, those arguments have, by and large, fallen by the wayside, and they've been replaced at the Supreme Court with a kind of quite technical argument about who receives work authorization under what circumstances. But I think the reason why they've fallen by the wayside, in large part, is one, because of an important feature of immigration law, and two, because of an important feature of our modern administrative state. So on the first, on the structure of modern immigration law, the most salient fact about modern immigration policy is that of the 22 million non-citizens who currently live in the United States, half of those people are deportable. Half. It's almost difficult to imagine another area of legal regulation where so many legal subjects are actually formally in violation of law. And in that context, as the Supreme Court majority in this earlier case that Josh mentioned recognized, it's actually incumbent. It's an obligation of the president and the executive branch to make very difficult choices about which small number of people from within this very large pool will ultimately be removed from the country. And I think that's part of what explains the scope of the program, is that, at its quickest clip, the Obama administration, which has deported a larger number of non-citizens than any other administration, was deporting something like 400,000 people a year. And at that pace, could come nowhere near deporting the full 11 million. And so the protection of these folks doesn't come close even to the resource constraints that the president faces. On the second, the administrative state. So if the scope of the program isn't the problem, maybe it's the fact that you come out clearly and say, these are the criteria we're going to use. Anybody who satisfies these criteria will receive relief. It's true that we kind of imagine historically that prosecutorial discretion is something that's exercised by individual law enforcement agents on a case-by-case basis. But what we see in the modern administrative state is that enforcement discretion is actually exercised quite regularly on the basis of rules. And while it does make those actions look kind of like law. Nick is absolutely right. It kind of feels more legislative. If we thought that actions that felt legislative raised take care problems, then most of the modern administrative state, which is executive branch officials making up a bunch of rules, would be invalid.
Great. So, Adam, you've drawn two distinctions. You've said immigration law is one where the president gets special deference, and administrative law as well. Josh, Justice Scalia, of course, taught administrative law before he came to the court, and he was generally very much in favor of deference by courts to administrative actions. The main case that is cited here is a case called Heckler and Cheney, where the Supreme Court said that agencies' decisions not to take enforcement actions are generally immune from judicial review. And if I understand Adam's numbers, he said that there are 11 million people potentially who could be deported. The administration issued a memo, the Justice Department did, distinguishing between the parents of US citizens and lawful permanent residents who could be deferred, and that's 4.3 million people. By contrast, they said the deferred program for the parents of illegal aliens would not be permissible. Does that matter? And why would not Justice Scalia, who was so much in favor of administrative deference, not have upheld this program?
So to answer your question, let's do a little history first. In 2012, Congress considered a bill called the DREAM Act. This is a piece of legislation I support as a matter of policy. It would provide a pathway to citizenship for the dreamers, people who are brought here illegally as children, grew up to be good people, graduated from school, upstanding human beings. The bill actually passed in the House, but it was defeated in the Senate. Roughly 6 months after the defeat of this bill, President Obama announced DACA, Deferred Action for Childhood Arrivals. This granted the deferred action to the 1.5 million dreamers. So in effect, the president couldn't achieve what he wanted through the legislative channels, so he accomplished something not quite the same, but a facsimile of it. Without amnesty, there's no amnesty. There's no grant to citizenship, but it was deferring the deportation and granting work authorization. Fast forward to 2014, it's in the news. Marco Rubio and the Gang of Eight bill, the amnesty bill, right? They actually passed a bill in the Senate that would have granted amnesty to a significant number of people who were here illegally, okay? Went to the House never voted on it. What did President Obama do? He went to the Rose Garden and said, well, if Congress won't act, then I will take whatever action I can. And over the course of the summer, he internalized and planned these different memoranda. And then 2 weeks after the election, elections have consequences, as we're told, 2 weeks after the election, he announced DAPA, the policy we're debating. And the night that he announced it, he released a memo from the Office of Legal Counsel. The Office of Legal Counsel is like the DOJ's lawyers for constitutional law. And they wrote a memo, they said that, look, we recognize that what we're doing here is potentially risky, right? They said there's a risk of exercising discretion, right? Why? Because it may amount to, quote, and this from Heckler v. Cheney, an abdication of its statutory responsibilities. The fact that the executive branch is adopting a policy of non-enforcement is so extreme, it could amount to be, quote, an abdication of its statutory responsibilities. The Obama DOJ, in contrast to what a lot of academics thought, recognized this problem, right? They understood that there's a risk that when you grant prospective deferred action and resulting work authorization, there's a risk of actually violating the Constitution. So what they said was, but don't worry, this is going to be done on an individual case-by-case basis. They said, what will save DAPA from unconstitutionality is that this is going to be done on an individual case-by-case basis. I humbly submit that this is not accurate. In fact, if you look at DACA, this predecessor, the grant was well over 90%, and the government has been able to identify a single case where a person was denied for discretionary reasons. Not one case. They can't. This is effectively what amounts to a rubber stamp. And the exact risk that they identified of this abdication of the law was how DACA was implemented. It was on this basis that the lower court said DAPA, which was modeled in a very similar respect, will result in the exact same outcome. So although the government of Texas has somewhat shied away from the argument that there's a wholesale abdication of the law, the question has become the manner in which this lawful presence has been granted, and the resulting grant of work authorization is not consonant with, not consistent with statutory responsibilities. And that's the gravamen of the case, and that's why the Supreme Court encouraged the parties to brief whether the take-care clause was violated. Now to the question of Chevron. It's one of my greatest...
Tell what Chevron is, because we're being...
Chevron, of course. Chevron
lawyerly.
is this case that was invented in the 1980s, which basically said, if a statute is ambiguous, the courts will defer to a reasonable interpretation by the courts. This basically means that these executive branch agencies can do whatever they want within pretty wide bounds. Although Justice Scalia was once a fan, he has been slowly creeping towards giving up on Chevron. And from what I've heard, he's given up on it internally. Another great regret is we will never hear what Justice Scalia says about this case. So many regrets that we'll have Scalia. But the point here is the Obama DOJ recognized there was a constitutional difficulty. They said this is why it's cured of that problem, and I humbly submit those facts do not support the case.
Great. So, Cristina, we've thrown around some cases, Heckler, Chevron, all these case names, but the basic idea is generally courts defer to executive actions unless, Josh says, the action represents a policy so extreme as to amount to an abdication of the president's statutory responsibilities. What's your response to the claim that this is a rewriting of the law, an abdication of the statutory responsibilities?
So I think that a lot in this case turns on how you frame the problem and what you analogize what the president has done to. So Josh begins by saying that what the president has tried to do is essentially legislate himself by enacting the DREAM Act, which Congress failed to pass. But the salient feature of the DREAM Act is that it would forgive a violation of immigration law and provide non-citizens with permanent status. DAPA does no such thing. All DAPA does is forbear deportation, but the executive, the president, retains the power at any moment to deport those who are given deferral of deportation, and it doesn't provide legal status of any kind. So I think that how you look at the case will determine the outcome of the judgment. I think that it's very clear, for reasons that Adam has given, that the president has not abdicated his responsibilities here for a variety of reasons. The most important is the one that he raised, that he is vigorously enforcing the immigration laws, but choosing how to enforce them because the possibility of complete enforcement doesn't exist. It's not possible. But much of the program that people are objecting to, the authorization for people to work, the access to Social Security benefits, and a variety of other things, are actually authorized by statutes. There is an argument the administration is making that Congress has actually authorized those things. And Congress has recognized this power of deferred action and the president's authority to forbear deportation. And so if you start to get beneath the claim that this large-scale program looks like the attempt to pass legislation that failed, and look at the sources of legal authority, you see there actually is a strong foundation for every aspect of what the president has done here. And the scale, while politically salient and important historically, is a red herring in this case.
Wonderful. Thank you for that response. Our great team is passing out note cards for your questions as we continue this great discussion. Nick, we are having in June a phenomenal Intelligence Squared National Constitution Center debate here on this stage. Resolved, the president has usurped Congress's constitutional authority. And this case we're talking about now is one example of that. Now, I hear Cristina say he hasn't here because Congress actually authorized deferred deportation, and there's a difference between deferring deportation and refusing to enforce the law. What is your response to Cristina?
Well, so let me say this. Josh has emphasized, and I spoke about the attempted legislative changes in this area. So Congress contemplated these bills and declined ultimately to pass them. But Adam says, and he's quite right, why is that relevant? We don't usually care about the things that Congress fails to do. Why is that legally relevant here? And I'm a formalist, so in general, I would agree. In general, I don't care what Congress fails to do. I only care about what they do. So why is this maybe different? Why does it maybe matter here? Again, it's because of this word faithfully. My colleague, Randy Barnett, has written about this and said, well, you know, it's tough to get at quite what that duty might be, but one place we could look is contract law, where we have this notion of good faith, performing your contract obligations in good faith. We can look at what the courts have thought that idea meant. And when we try to adjudicate questions of good faith, the very same action, doing the exact same thing, could be a violation of good faith or not, depending on your mindset, depending on quite what you were thinking while you were doing it. Were you actually trying to fulfill your obligation, or were you actually trying to subvert it? And it might matter. The mindset actually might matter as to faithful execution. So that's why I think it matters. If the president were to stand up and say, look, I know my obligation is to enforce the immigration laws entirely. And if I had $1 billion to do it, I would deport all these folks. Because I don't, I will have to enforce this law to the maximum extent that I can, given the resources that I have. I wish I had more resources, but I don't. This is what I'll have to do. That, I think, is what the mindset of the president is supposed to be. If the president says in effect, I think this is a bad law. I want for Congress to change this law. And if Congress fails to change this law in the way that I would prefer, I am going to behave as though they did. That, to me, is the problem of unfaithful execution. It's actually an attempt to undermine, an attempt to the extent that he can, create the legal regime that he wishes was in effect, but isn't. Now, maybe just to complete that point, I don't think any conversation about this should happen without this quote. America is a nation of, this is President Obama. America is a nation of laws, which means I, as the president, am obligated to enforce the law. With respect to the notion that I can just suspend deportations through executive order, that's just not the case, because there are laws on the books that Congress has passed. There are enough laws on the books by Congress that are very clear in terms of how we have to enforce our immigration system, that for me to simply, through executive order, ignore those congressional mandates would not conform with my appropriate role as president. I don't agree with a lot of things that this president says, but this is exactly right.
Adam, first of all, obviously, what was President Obama talking about there then, and how does he distinguish that statement from the case at hand?
So we don't know exactly what he's referring to in those statements. I do think that, so I have two thoughts. In a way, I think I'm not sure I'm on board with the idea that the subjective intent of political actors when they make decisions about how to go about their duties, whether they are members of the Legislative Assembly or members of the executive branch, are very often going to be relevant to the constitutionality of their actions in the way that Nick is describing. In part because I think to elevate intent to that degree of importance would imagine a kind of politics that we don't have, right? We have a deeply competitive politics where, of course, it's a commonplace for members of both parties in all kinds of different institutions to say, each day when they get up, my job is to go out and try to stop the agenda of my opponents, right? So that itself, I think, we'd be in trouble if we thought that was a relevant marker of the constitutionality of official conduct. I do think, in a larger sense, though, Nick is probably right that, of course, there are outer limits. If the president, announced a moratorium on all deportations, it might raise serious questions about his obligations under the Take Care Clause, and that might be a way in which to understand these statements that, as I say, I'm not quite sure what he was referring to. But I think the most important point, and you're absolutely right about this, is that you can't make sense of the president's obligations under Article 2 without understanding his legal obligations under a particular regulatory regime. And here, in American immigration law, that means, to go back to my first data point, making sense of why it is that we have half of all the people who are non-citizens in this country living here without authorization. Without thinking about that question, I don't think we can understand what the obligation of the president is. And there are two ways to think about that state of affairs. On the one hand, we might imagine it just reflects a terrible failure of resource allocation or congressional and executive will or something, but that the perfect state of the world would be a world in which we would in fact have no people living here without authorization. That's one understanding of modern immigration law. I think the history of immigration law over the second half of the 20th century makes clear that that in fact is not an accurate account of how we ended up in this situation. We ended up in this situation because for a very long time, Congress and the president and a variety of officials working in concert essentially set up a large shadow immigration system, a system that many people were happy permitted lots of folks to come to the country without authorization, but to live here nonetheless. And I think that account of the development of immigration law shapes and should shape the way we think about the obligations of the president when it comes to enforcing the law. So it's not just that the decisions by the president to forbear deportation must be defended through the lack of resources that are inevitable in a system with this large number of unauthorized folks, but instead that, in a way, Congress decided over the course of a half century to effectively hand over the keys to our immigrant screening system to the president and to tell him, we are going to create a very large pool of people who are deportable, and we don't think and we don't want you to deport most of those folks. And that means, by definition, the rules of deportability, they're not what's going to matter. The discretionary decisions made by executive branch officials about whom to deport, that's what's going to count.
Very interesting. So Josh, both Adam and Cristina have said, in effect, Congress either tacitly blessed this by delegating decisions about non-enforcement to the president, or explicitly blessed it. And I want you to tell our audience about Justice Jackson's opinion.
That was my next point. I was going there, Nick.
Excellent. Good. Well, then I'm setting it up perfectly. This is a flawless intellectual arabesque.
We are on the same wavelength. So let me tell you about one of my favorite cases.
Tell us about the case.
And here's a fitting
What do you
tribute.
think of it? Yeah.
Do you know Scalia sat in Jackson's seat?
He did.
He did. So in 1952, at the height of the Korean War, right before the election, President Harry Truman made a decision. The steel mills in Youngstown, Ohio, were about to have a strike. The workers were about to go on strike. And Truman said, wait a minute, if these steel workers go on strike, the entire war effort in Korea will shut down. I cannot afford that. Our troops overseas will die. So what happened? Did he ask Congress for a bill to seize the steel mills? No. He did it unilaterally. He said, as the commander-in-chief, I will issue an executive order taking under my power these private property. Okay? And by the way, what does that mean when he takes private property? If any of the workers went on strike, they'd be arrested by military police. So these are very stark circumstances. The steel owners brought a suit. The case is called Youngstown Sheet and Tube Company versus Sawyer. And they argued that the president lacked the authority to seize the steel mills. And this case went to the Supreme Court in a very short time. And in my mind, the most important decision of the 20th century, not Brown, not Roe, Youngstown.
Wow.
Without a doubt. The most important decision of the 20th century. The court said to Mr. President, no, you cannot do this. One note, all the Roosevelt appointees voted against Truman, all the Truman appointees voted for Truman. So take that for what it's worth. But the court said, by a vote of 6-3, you cannot take these mills. But the decision you remember most is not the majority decision by Justice Hugo Black. The decision you remember the most is by Justice Robert H. Jackson. This was an amazing human being, one of the great justices of all time. He was a prosecutor at Nuremberg. By the way, for those of you who think that the court can't operate with 8 people, he went to Nuremberg for a year while he was a justice. They operated just fine for a year without him. So, work that in.
Well, Justice Frankfurter did threaten to punch him in the nose at the time.
Justice Frankfurter hated, he was a scorpion. He didn't like anyone with respect to Harvard. So Justice Jackson was a great man. He worked in the Roosevelt administration as the Solicitor General, the Attorney General. And what did Justice Jackson say? To understand the executive's power, we can't look in the abstract. We can't be formalist with respect to my friend Nick, right? We have to look at the relationship between the powers of the president and the powers of Congress. So he said, look, if the president and the Congress are on the same page, the president's authority is at its maximum because you have the entire elected branch of the U.S. working together. But if we're in a situation where the president and Congress are at odds, he's at its lowest ebb, right? Because the president only has his own power. And there's this hazy nether region called the zone of twilight. Rod Serling, eat your heart out. The twilight zone, Jackson had it first. This zone of twilight where it's unclear whether the president has the power or not, okay? And this is a framework that every justice has adopted. Another cool point. Do you know who was clerking for Jackson the year Youngstown was decided? William Rehnquist. Oh. 30 years later, William Rehnquist wrote an opinion called Dames Moore v. Regan. Know who Rehnquist's clerk that year was? John G. Roberts. So there's a beautiful historical pedigree about this case that's magical. So how does Youngstown inform our case, right? We ask, is Congress in fact supporting this? Now, with respect, the government has argued that apparently a regulation by the Reagan administration, which no one noticed until Marty Lieberman blogged about it, a regulation by the Reagan administration gave the president all this power to quote my friend Justice Scalia, Congress does not hide elephants in mouse holes, right? Congress doesn't hide these great powers in these little interstitial crevices of the US Code. I don't think so. So to the extent that the statute actually gives authority, we should read it more narrowly. But more broadly, after this happened, the House of Representatives passed a resolution saying, no, this is unconstitutional, right? We have a clear Zone 3 case where Congress said, this is unlawful, Mr. President. You cannot do this, right? And I think that directly informs the legitimacy of this case and whether President Obama is in fact acting. And one more point. On one occasion, a mother who was not here legally said, Mr. President, can you give me deferred action, right? Can you do for me what you did for the Dreamers? He said, quote, I am not a king. We cannot simply ignore the laws. When it comes to the Dreamers, we can do it. But for the parents of US citizens, we cannot. Less than a year and a half later, he did exactly what he said he could not, which makes the case for bad faith.
Interesting. So, Cristina, Josh has told us about Justice Jackson's Youngstown case. Just a review class, we have our 3 categories. When the president is acting with congressional support, his power is at its zenith. When he's acting in the face of congressional opposition, his power is at its lowest ebb. And when he's acting when Congress hasn't spoken, he's in a zone of twilight. And absolutely. And Cristina, Josh says that here he's in the lowest ebb. Do you believe he's in the zone of twilight?
So this is another example of where framing is extremely important and where a bad analogy can lead us astray. So what, what President Obama has done is nothing like the seizure of the steel mills. That was an extraordinary act, directly contrary, according to the court, existing statutes. The important thing to understand about what President Obama has done here is he's exercising a quotidian power of the executive branch. The president must make decisions about how to enforce the law. That's his constitutional responsibility under Article 2. And so the decision about whether or not to deport this category of individuals is comfortably within a traditional, ordinary power of the president. We're not talking about an emergency situation or some sort of usurpation of private property or anything of that sort. With that as a threshold matter, I think there's nothing that exists in law that puts us in the so-called Zone 3. Congress has not expressly prohibited anything the president has done here. Now, we can definitely argue about whether the statutory basis that the government's claiming for work authorization, Social Security benefits, and those sorts of things cover what the president has done here. There are legitimate statutory arguments to be had. I happen to think the government is on strong foundation there, but that's a matter of ordinary statutory interpretation and is not a clear example of the president doing something in the teeth of an existing congressional statute. So at best, and I think this is probably the right way to think about it, for most of what the president's done, we're comfortably in Zone 1. He has statutory authorization for most of what he's done. The structure of immigration law, as Adam describes it, contemplates his use of this enforcement discretion. He has Kennedy's theory of enforcement discretion, Arizona versus the United States. At worst, we're in the zone of twilight, where there's some ambiguity, and we have to fight it out in the courts. But ultimately, I think that ambiguity, because we're talking about an ordinary executive power, augurs in favor of the president in this particular case.
Wonderful. So we have a riveting disagreement about which zone we're in. One thing that's quite clear is how different Washington and the court and the relations between the president and the justices were in Jackson's day than ours. Adam, you talked about now the polarization that leads both sides to think their job is to block each other. After the steel seizure case comes down, Truman is really upset because all of the Roosevelt appointees have voted against him. So Hugo Black, the Roosevelt appointee, decides to invite Truman over to his house for drinks along with the other justices. Truman's kind of sulking at the beginning, but then he has a couple drinks and loosens up and says, "Hugo, I don't think much of your law, but by golly, your bourbon is good."
That's a verbatim quote, so he's got it right.
It's just great. And then I think Truman played the piano and they all sang together. So would that we were in those days. We have phenomenal and really sophisticated questions from our spectacular audience, which I need my constitutional reading glasses to read. And I'm going to, Nick, you can have the first one. What is the constitutional remedy for the failure of one of the branches of government to carry out its duty? President, impeachment. Supreme Court, uneven number of justices. Congress, other than elections? What's the remedy for a take-care violation?
Yeah, I wasn't sure. I'm not sure I completely understand the question. But we have this case, and so the court can order a remedy and can order the DAPA or DOC, the president, to behave to rescind DAPA or DACA, I suppose. But maybe the more important remedy here is political. So if you all are persuaded that the president is failing to take care that the laws are faithfully executed, that's a fine reason to vote against the president, perhaps against his party, against senators who support that, for example. The remedy for a lot of constitutional violations is ultimately political. So it's quite interesting that the court has taken this case, taken this issue up, because the court doesn't usually adjudicate take care clause questions. And there are these interesting technical questions of standing and whatnot, which we haven't gotten into. The court may actually not reach the merits. But if the court doesn't reach the merits, that doesn't mean that there's not an actual constitutional issue here. We actually are obliged to consider this constitutional question quite regardless of whether the court does, as a duty of citizenship.
Wonderful. Well, that's what we are trying to perform tonight. Adam, here is a question for you. If there are 11 million people in the country illegally, and Congress gives the president the funds to deport 400,000, how is the president prioritizing who gets deported any different than a prosecutor choosing who gets prosecuted, or a town manager deciding what roads to fix with limited resources? I think you'll like that.
Right.
Yes, exactly. Excellent question.
I concur.
Let me take that one.
You give it a shot, and then Josh.
I'll just say one additional thing. So I think that is exactly the point, and that's why early on in the litigation brought by Texas, the big question was how exactly this exercise would be distinguished, and the real effort was to argue that announcing publicly the criteria and having the criteria be relatively rule-like, that those two things made it different than the exercise of discretion wielded by a prosecutor in an individual criminal case, for example. I think for purposes of constitutional law, it actually does not make it different. So it's true there are times when rules are nice and times when standards and discretion are nice, and it's true that there are times when it's great for government to be transparent, and there are times when it's beneficial, actually, for the government to be a bit more secretive about its enforcement priorities, like when it sets up a speed trap or something. But in general, American constitutional law does not elevate those choices, the choice between rules and standards and the choice between secret and transparent enforcement priorities, to the level of constitutional requirement. And here, in a world where it has not been elevated to the level of constitutional requirement, it's also really apparent exactly why the administration made the choice to be clear about this and to be rule-like. And that is because really what was going on was this was an effort by the president and the senior leadership of the Department of Homeland Security to actually effectively establish those priorities. So unlike was it a county supervisor or a town supervisor?
A town manager deciding what roads to fix.
Yeah, so unlike a town manager who might just have to pick up the phone and call one person to allocate resources to the road in my neighborhood, the problem was that in this long game of telephone, the priorities that the president and Jay Johnson, the head of the Department of Homeland Security, wanted to establish were not actually filtering down to the 10,000 line-level enforcement agents in the immigration bureaucracy. So they weren't actually wielding the priorities in the way that the president and the senior leadership wanted. And so this program was an effort in a way to essentially take control, meaningful control of that discretion, and decide in a programmatic way how it should be exercised.
Great. Josh, do you want to say why it's not like prosecutorial discretion or fixing roads?
So how many people here, show of hands, have ever gone 10 miles over the speed limit? 20 miles over the speed limit? 30 miles over the speed limit? 40 miles over the speed limit? Okay. Now, what if I told you, right, that the sheriff in your town gave you a piece of paper saying, I give you permission, right? I will not pull you over for going 40 miles over the limit, and I'll give you a get-out-of-jail-free card. I may revoke it at any time, but I'm going to give everyone in this town who's an upstanding citizen this card. How many people now go 40 miles over the limit? All of you. This is why this is different than discretion. It's not simply prioritizing. You're effectively saying we will prospectively license you. Sure, we can revoke it. We've never actually done it before, but we could revoke it, and it gives you the license. Now, to Adam's point, right, the big problem was 10,000 border agents weren't doing what the president wanted, right? So this entire thing is an HR policy, right? It's an HR policy. No solution is fire them. Why can't you? Because they're unionized, right? So instead of actually disciplining a civil workforce, you're making this vastly unprecedented, unconstitutional policy. And I find it very difficult to actually, internalize this. But indeed, this is what the government's arguing. This is a way of making employees comply. But there's a vast cost greater than that, right? You're actually effectively licensing people, saying, we will not enforce this law against you. We won't, right? And we can maybe take it away, maybe not, but we will do this in a manner that you know in advance how you're going to behave. And that's quite different from the prosecutorial discretion of your average run-of-the-mill prosecutor.
Thanks for that. Cristina, the president's argument appears weak. He previously stated he could not take action. How does this square with his current position? The founders made it difficult to pass laws purposely. We do not have a king.
So I'm glad that question came up because both Josh and Nick have also invoked the president's statements. If I were the Solicitor General, would I be wishing right now the president had not said those things? Yes. The answer to that is yes. But I actually think that those statements are both immaterial to the legal question. I agree with Adam that the subjective intent of the president is not really something that we can know, even though he's made public statements to that effect. But I also think more importantly, the statements the presidents make are part of the warp and woof of politics. And I also think that we should keep open the possibility that presidents might change their minds after consulting with their legal advisors. So it may be that after the president initially adopted the program that deferred deportation for the childhood arrivals that Josh mentioned, there was some concern that that was about as far as we could go. We're not in a world where there are clear lines that we can draw between what's permissible and what's not. And so there might have been some hesitation. I also think that the context of that statement that Nick read might have been resistance to the constituencies that were demanding that he do as much as he possibly could or push the law as far as he could, the immigrants' rights community. And so he was expressing a form of resistance to the idea that you could the president could do whatever he wanted. But over time, through consultation with legal advisors and a change in the political landscape, he may have come to a different point of view. And I think it's crucial to not suggest that because the president does something for political reasons, it must necessarily be in bad faith. I think it's perfectly fine for any president, any politician, to make a judgment for political reasons and still to be within the bounds of the law. So the fact that he might have gained electorally in 2012 by deferring the removal of children does not mean that he doesn't have that power. And the fact that he announced DAPA after the 2014 election and he had nothing left to lose politically doesn't mean that that is unlawful. President's motives are mixed, and enforcement policy is shot through with politics. But our entire government is shot through with politics, and I don't think that you can have a realistic conception of government that doesn't acknowledge that that will play a role in the decisions that get made, but it doesn't make them illegal.
Great. Nick, Cristina says very concisely the president can change his mind. He can take political considerations into effect. And one of our great audience members has another statement from President Obama. How does Obama saying, I just took an action to change the law, referring to his executive action, affect the debate?
Well, yeah, exactly. So, right. So I say that these actions look legislative, and it's nice rhetorically that actually the president has said that he's changing the law by doing this. I wouldn't quite hang my hat on that. I don't actually think that that's going to play a role in the Supreme Court decision, but yeah, I think it informs the flavor of this discussion, and it's really, I certainly agree, they're not bright lines here. They're not bright lines, and getting at quite what the word faithfully means is going to be tricky. I quite agree about that. But these kind of rhetorical flourishes of the president actually, I think, do inform whether he is acting in good faith or not, whether this is faithful execution of the law or not. I think I'm maybe just make a general point,
Sure.
and maybe we should have made this point at the outset because we usually like to do this when we do our debates, but we should just emphasize, again, this conversation is a constitutional question, not a policy question. Right? So Josh and I are taking no position at all on whether the law should change.
I support it. I do. In fact, I do. I think it should change. I support the DREAM Act. I support I support it.
Josh supports the DREAM Act. I'm taking no position about it. This conversation's not about that. It's not about whether you think it's a good thing to legalize these folks or not, whether you feel bad for these folks or not. That's not what we're talking about. We're talking about whether this was done in the proper way, whether the president had power to do this, or whether Congress should have done this. And a thing that you can do, kind of a mental trick to help yourself separate out the legal question from the policy question, is run some hypotheticals for yourself. So if you like this action, will you like it when a Republican president doesn't enforce the capital gains taxes? As I don't have enough resources to collect all taxes, and so I'm just not going to collect capital gains taxes. I don't have quite enough resources to, and he doesn't even have to use the word resources. Just as I wish that they had repealed the capital gains tax, and therefore I'm going to not collect the capital gains tax, or your favorite environmental law, or whatever law you might actually feel attached to. How will you like it when the Republican president does that? And if you won't, how are you going to distinguish this case from that case? I think you're going to have a hard time doing it.
That's a great challenge to the audience. I began by remembering Justice Scalia's challenge to all of us that we separate our political from our constitutional conclusions. And in a moment, we're going to actually take a constitutional vote. And I'm going to ask you not whether you think that the program is a good idea, but whether you think it violates the Take Care Clause or not. Adam,
No pressure.
No pressure at all. I think a couple technical, it might be time for some prediction and some technical stuff. So how's the court going to vote? And what would a 4-4 split do? And how will Justice Scalia's absence affect the case?
So let me take those in reverse. I think the most likely way in which Justice Scalia's absence could affect the case is actually in one of these technical areas, not with respect to the principal question we've been discussing, whether the president exceeded his constitutional authority under Article 2, but instead whether Texas actually had the right to go to court to sue about this at all, whether it had standing in a legal sense. And I think his absence could, in theory, be really important because much of his career, Justice Scalia's career, both as an academic and as a jurist, was dedicated to the notion of limited standing doctrines, which in his belief would ensure that courts played an appropriately modest role in our legal and political society, where they didn't decide all the most important social policy questions of the day. And so it's possible, reading his jurisprudence, to imagine, in particular, based on a couple of recent high-profile dissents in cases brought by other states, like Massachusetts, involving global warming, that he might have concluded that the Constitution just doesn't permit states to sue about this kind of a grievance. And in that way, his absence from the court could actually be really consequential. If the court does end up taking the case on the merits and then dividing 4-4, well, that means that the Fifth Circuit's decision will stand, right? So the Supreme Court itself won't create precedent, but it does mean that President Obama's policy, the DAPA policy, will continue to be enjoined, and the president will not be able to accept applications or provide deferrals at any point before the end of his presidency. Now, whether that will in fact happen, I have no idea. I'm a terrible prognosticator, but I guess I do think that even if the administration prevails, the timing is such that it's actually really unlikely, I think, that we'll see a significant, meaningful implementation of this policy before the election. And so really what's at stake is precedent about presidential power and the setting of the stage for really important decisions about immigration law that'll be made by the next presidential administration.
Great. I think, Josh, the last word is to you. I mean, we've had some suggestions from Cristina and others that it might not be, or might not have been a 5-4 decision, that Chief Justice Roberts and Justice Kennedy might have voted to defer to the president. In predicting, I'm asking you to channel the justices' constitutional philosophies. What do you imagine will happen? And the administration really wanted this to be decided fast. They asked for it to be fast-tracked. If it does split 4-4, might they decide to hold it over for re-argument and tell us
my points.
Well, we're channeling each other.
Wavelength.
This is a beautiful interview, and you're going to have the last word.
So thank you, Mr. Rosen. So the short answer, right, is the court doesn't need to decide this case at all. What executive action giveth, executive action taketh away. If the court holds this case over for the next term and a Republican president's elected, this case goes away. They don't need to make a difficult constitutional decision on the merits with a shorthanded court. They don't need to solve this tough question of standing on a shorthanded court. All they have to do is hold the case over for 6 more months, and then the next president will say, adios. Or President Hillary Clinton or Bernie Sanders, whoever you like, will say, let's roll. And then they can decide with a full court. In my mind, that's perhaps the best possible option in honor of Justice Scalia's legacy. Don't decide the case until you actually have to. Let this case go on.
Beautiful. Well, we are about to take our vote, but ladies and gentlemen, this superbly substantial discussion is just a preview of the extraordinary conversations we're going to be having over the spring and summer. The nation will be transfixed by the constitutional debates before us every day, and here at the Constitution Center, we will bring together people of all perspectives to debate them. And that's why I want you, as you file out, to go see Rebecca Bolden, our great director of membership, and if you are not a member, join the National Constitution Center so you can get word of all of our programs and come to incredibly glamorous, exclusive events where you can meet the panelists and hang out with us. Okay, it's time for the vote, and the question is not political but constitutional. Having heard the arguments on both sides, do you or do you not believe that the president's executive actions violate the Take Care Clause of the Constitution? Who believes that his actions do violate the Take Care Clause of the Constitution? And who believes that they do not?
I'd say it's a 4-4 split.
It's close. I have two more questions. Whose policy views diverged from his or her constitutional conclusions? Beautiful. There you get the Frankfurter Prize for that beautiful moment of principle. And who changed his or her mind after hearing the debate? Wonderful, too. Final question, whose mind was open to the arguments on the other side? Ladies and gentlemen, please join us in thanking our panelists.